Yes.
As a court, please, my lord, case number CC 67/2020, State versus Measures Musi Sibia and 4 others. On the 17th of May 2023, before Judge Maumela, the appearances for the state are still the same.
Baloyi, before we start, 2 things. The first is I would like to know, are there problems with the accused being brought in time? Because each time in the morning when I inquire, I'm told that not all the accused are around, and if we check, it's affecting our ability to start when we want to.
No, there isn't any problem, my lord. It hasn't been brought to my attention. In fact, I think all the accused were here on time today.
Okay.
As on any other given date, my lord, they are always here on time.
Okay.
Inkinga yini yokuthi ke abamangalelwa balethe enkantolo ngesikhathi shushisi uyaphendula ke babaloyi ukuthi cha mina angaze ngitshelwe okuthize okumayelana ke nokuthi abamangalelwa ke bayahluleka ukuthi balethwe ngesikhathi.
Yes, when we adjourned last, you were to address. And before we go there, the understanding was that I will receive heads from everyone before now, which didn't happen. So I don't know, did you receive heads?
I have received heads, my lord, except from one counsel. But counsel was in chambers yesterday to hand deliver them at about 1600 hours. And apparently he couldn't find anyone to deliver the heads to. But I think
so I don't know, do people have copies for me? Because nothing was sent to me. I checked very late in the night. I didn't see anything. I checked this morning. I didn't see anything.
Well, we did file ours, my lord.
Yeah, yours I did. Yes. I did find. I think.
I think my other friend, my other colleagues can speak for themselves. As I say, I did receive everybody else except from counsel for accused number 4, but he was here yesterday to deliver the hard copies.
Shuthi ke bonke ke abameli bakwazile ukuthi balethe ke amaheads wabo wokuphikisana ngaphandle ke komnelo oyedwa kanye no-advocate oyedwa. Kanti ke ujaji uyasho ke naye ukuthi angitholanga mina amaheads, kanti ke amaheads okamshushisi ngiwatholile kodwa ke angiwatholanga ke shuthi njengoba umshushisi esho ukuthi abanye bakwazile ukuletha kodwa ke omunye nje yedwa nje ongakwazanga ukuthi alethe lama heads. Thank you, my lord.
My lord, I did send heads to everyone whose address I got. I believe heads were sent to you, but I'm not sure. In any event, I do have a hard copy. with your permission, if I can hand them up.
Something has just been brought to me. Is it something like this?
No. It has heads of argument, members of the electronic media.
Melike we electronic media uyasho ukuthi hayi cha mina awami ama-heads ngafakile mhlambe ke uma ngabe inkosi enkantolo ingathanda ngiphethe nje ikhophi yakhona la kimina manje ujaji uyasho ukuthi hayi khona ke sengitholile nje manje.
Pieces that got my lord, I also did send mine, although mine were an hour late yesterday. I however also have a hard copy, my lord, which I beg leave to hand in.
Uyasho nawami ngiwafakile nanoma ke ngiwafake mhlambe ihora emva kwaleso sikhathi sasibekiwe ukuthi sifake lama-heads lawa. Izolo ke ngiwafakile kanti khona ke icopy ayifaka la enkantolo njengengxenye ubufakazi ukubonisa ukuthi ngempela uwalethileke.
Accused number 3. Indeed, I also filed my heads yesterday, and the address that I used there was Mr. Ashley Zukula, the address that I've been having all along in communication since I became part of this court. So I'm not so sure whether that address is still working or not, but we informed our colleague who's assisting the court that apparently there's a challenge with the address. I don't know whether that address is the one that relates to Ashley Zukula or it's something else, but nonetheless I did find mine.
Yeah, Ashley Zukula is not around. In his place we have the secretary that we have.
As it is a court matter, but nonetheless I also have a hard copy of the case as such, my copy.
Uyasho ke no advocate Nisi ukuthi hayi nawami ke ama-heads ukwazile ukuthi ngiwafake ngiwathumele la enkantolo kanti ke ngithi ngathumela ku-Ashley Mzukula angazi noma ke ilona akhile li-right ke lelo lokuthumela lawo ma-heads ujaji uyasho ukuthi cha u-Ashley akekho kwamanje kanti nginomlekeleli la okuyena ke ongilekelelayo kwamanje.
Yes.
May it please the court, my lord, I still confirm my appearance on behalf of accused number 4. My lord, I was here yesterday in the afternoon, around about 3:45 in the afternoon. I could not find anyone who was going to receive my heads. I then contacted my colleague, Advocate Banoi, for the state for assistance. Indeed, he has confirmed, my lord, that I did phone him to indicate that I was here in court and there was no one to receive my heads. I had a problem with the network where I'm staying. I couldn't send mine, but I have made all endeavors to email my heads to the email address that was provided. It's rcilebe at Judicia. I don't know whether that email address is working or not. Yes. I've also handed my lord the copy of my heads. Thank you.
Ubaba uNomalo ke okuyena okhulumela umangalelo wesine kuleli cala uyasho ke ukuthi ube khona la enkantolo ngabo 3:45 ethi ke uzofaka wakhe ama-heads kanti ke akazange athole umuntu wase ke ufonela u-advocate Baloyi naye ke u-advocate Baloyi wase uyaqinisekisa ukuthi ngempela kunamuntu lapho obezokwazi ukuthi mhlambe athole lawo ma-heads kanti ke uyasho ukuthi isizathu kube ukuthi ngibe nenkinga ne-network la bengikhona ukwazanga ke ukuthi mhlambe ngenza ke ngaleso sikhathi lokho kufanele ukuthi ngikwenze kodwa ke egcineni kwazileke ukuthi ngibathumeleke ama-heads namanje nje ngikwazile ukuthi ngiwafake nje ama-heads.
My lord, my apologies suffer if the heads arrived late, my lord. I also used the address for R. Silepe, of which when I verified with the Lordship's registrar this morning, I discovered that it was down, and then I've been provided with a Gmail address of which I had used this morning, and I'm told that the registrar has made the copies available for the court, my lord.
Yeah.
As the court pleases.
Grantige u-advocate Mshololo uyaxolisa ke ukuthi ama-heads angafiki mhlawumbe ngesikhathi la befanele ukuthi ahanjiswe khona ke sengisho la enkantolo uthi ke mina ke ngithe ngisebenzisa ikheli la elithi R Silepe kanti ke kwatholakala ukuthi ke lelo kheli ke li mayelana ke nalo ophansi nje kanti ke nganikezwa ke i-email ye-Gmail ukuthi ngithumele lawo ma-heads khona nama-copy ke akhona balawo ma-heads ngenze njalo.
Yeah. Advocate Baloyi, I believe then you did have sight, unlike me, you did have sight of the heads from your colleagues.
Yeah, some of them, not all, you know. Some we just we received shortly before we resumed this morning. So I will just go through them as after my address.
Okay.
Babalo yasho ke ukuthi hayi ukuthi ngiwathole wonke ama-heads lawo kukhona amanye engiwatholile khona amanye engawatholanga kanti ke ngizozama ke ukuthi emva ukuthi ngikhulumisane nenkantolo ngizama ukuwabheka ke lawo ma-heads.
Yes.
As a court please, my lord, before the start of the proceedings, I tried to inquire from my colleagues if each should be allocated a certain amount of time to address the court. We haven't really reached consensus. I don't know if the court would like to allocate perhaps speaking time to each speaker. If in the absence thereof, we'll just carry on. There are 6 of us, and that might take some time if we all have unlimited time to address the court.
Yeah, I think we don't have to lose sight of what has already happened. What has happened is that everyone has addressed without, before the written heads, and you are now to address in the light of what was submitted by your colleagues. And I now have before me, which only happened now, this morning here in court after we started, the written versions of the arguments of each and every one. I believe that after your address, or even before your address, we can check if there are crucial issues that need to be added, because I have these heads. I'm going to go through them. Actually, that is what was agreed the other day, that whatever people cannot slot into the time allocated, they will put it in writing, just as Mr. Rosengarten promised that thing. So I'm not expecting protracted addresses unless someone feels that there's something vital that needs to be added to what was submitted on the day we postponed.
As the pleases.
Manje ke angokuthi sizoqhubeka ke ngenqubo kube naleyo nto leyo ukuthi ukushishisa ibuza yona ukuthi ngabe ke isikhathi sobe sanele yini ngoba ngibheka nje ngiyabona ukuthi siba u6 la futhi ke izazi zomthetho siba u6 manje ke uthi ngiyabuza ukuthi ngabe lokho kuyokwenza ke ukuthi isikhathi sisetshenziswe kahle ke manje uthi ujudge uthi angisho ihloko zokubangisana seyifakiwe kanye ama-hits asefakiwe njalo kanti kuzomela ukuthi omnye nomunye ozokhulumisana nenkantolo akhulumisane nenkantolo eloku ekhumbula ukuthi ama-hits esefakiwe kakhulukazi ke futhi mayikhulumisana ke nenkantolo ebekhulumisana nenkantolo mhlambe uma ngabe kukhona okuthize okushiyeke emuva uma kufakwa le ihloko zokuphilisana ngaleyo ndlela mhlambe izihamba kahle.
Malot, as far as we are concerned, we'll take the court through our heads. We've made some additions. As far as reference to case law is concerned, we'll only refer to the relevant portions.
Sizocela ukuthi sikwazi ukuthi siphaneke ngesithombe sama-hits wethu.
Are you going to be repeating what you have already submitted?
No, I'm not going to repeat.
Right.
Yes.
Cha angizophinda lokho esengilobile okanye engibhale phansi kuma-hits.
My Lord, our heads of argument are structured as follows. Under introduction, we set out the course of this matter, the objection that has been conveyed by the witness to the state, as well as the ground for such objection. And as I've already indicated, my Lord, on Monday, we addressed the court on these grounds, and we are not going to repeat them as we've just mentioned, my Lord. Suffice to mention that the matter is partly heard, and that the state is due to lose the evidence of witness number 1 on the list of witnesses.
Manje ke thina ke ngendlela ihloko zethu zingakhona ukuthi ke sizokwazi ukukhulumisana nenkantolo. Okokuqala sikhuluma ke nge-introduction okanye ke zama ke ukuthula la enkantolo ukuthi siphetheni okanye siqukethe ini. Okokuqala imbangela ekhona nje kuleli cala. Okwesibili inkinga ufakazi abenayo mayelana nokuthi ke icala liqhutshwe okanye lihanjiswe ngendlela ejwayelekile njengoba beloko liqhubeka kwabanye ofakazi. Kanti ke kukhona ke nezathu ezenza ukuthi ke kube nenkinga yokuqhubeka ngendlela ke efanele okanye ejwayelekile kanti go Monday inkantolo ikwazileke ukuthi ithu uhlala kwaseke kuba nendlela yokuthi umshushisi akhulumisane nayo inkantolo mayelana ke nalenkinga esikhona okanye lenselelo esikhona engakusho nje ukuthi le cala ke kuyiqala lokulichubeka aliqali nje ukuthi liqhube la enkantolo namhlanje okanye ngomsombuluko.
The issue therefore arises in the course of an ongoing trial.
Kanti ke lento lena ke iqhamuka njena ke iqala lokuliyaqulwa senjo lenselelo ebe khona ngomvulo iba khona nje iqala lokuliyaqulwa okanye liyaqhubeka.
Can I interrupt you? Sorry for that. I'm checking how far we will go at this rate, because there is this approach, there is the other approach where Advocate Baloyi will cover a few paragraphs and then we have an interpretation, because the way it's going, it will take overly long. But I don't want to do it if it will not benefit the accused.
I don't intend going over the argument I presented. It's all in the heads of argument, together with the citations I made when I last appeared and argued before you on Monday, together with the additional quotes I referred to. I have one or two points to make, as well as one or two responses to my learned friend arguing for the state. So I won't be more than 15 minutes.
Mr. Rosengarten, all I'm asking is whether interpretation should be sentence by sentence.
My Lord, our view is that it need not be sentence by sentence.
Yeah.
As the purpose, my Lord, that was our view that case citations and quotes should not be interpreted, my Lord. I think that's the view from the left here and the right, at least to this point, my Lord. As the court, please.
I think it is even not necessary to interpret what has been argued here. We'll definitely endeavor to explain it to our clients, in the interest of time. Thank you, Mamat.
Thank you, my dad. I think I can do the interpretation. I can do the interpretation to my client later on.
Okay.
My Lord, we also can dispense with interpretation during these arguments. I will interpret for my client.
Okay.
I wish also to interrupt the court, my Lord. I've just been asked by Mr. Tefo to report that he is sitting here in court as a watching brief, my Lord. As the court pleases.
My request to my learned colleague has been just to introduce me, then I will stand up and give the reason why I'm here. That is what I requested from her.
No, she said you are a watching brief. I think we should leave it at that, because we are busy with the process. I've been told by Advocate Mshololo that
yes,
you said I should know that you are here as a watching brief, and I think that does it.
she didn't put it in a correct way, in the right context.
No, please.
I will put it in the correct context.
Mr. Tefo,
As a watching brief,
the other day outside here, we started late because I was explaining to you that these accused persons have paid these representatives who are here to represent them in this case. And whatever time we spend here, it is at their expense. Now you are watching. That's what you are telling me. I'm asking you to stay put and watch that brief and allow the representatives of the accused to play their roles. Now it is the opportunity from Advocate Baloyi to address me. Now what you want to do now is coming in between, and it is disturbing these proceedings. Sit down and watch. I am not saying I'm allowing you to sit down and watch the brief, or I'm disallowing you, but I have been told and I have noted it.
Your Lordship, like I said, let me put it in the right context.
No.
I'm not here to watch, to sit and watch.
You are not going to address me.
I've been given instructions, several instructions by Senzo Meyiwa, the brother of the deceased. I've been given the instructions.
You are disturbing.
by
You are disturbing court. Please sit down, or I will order that you be taken out. You are disturbing us.
If you feel like that, Your Lordship, you can do that. But you must know that you're depriving the right people who are affected by this.
Yeah, yes.
This witness is a witness of the great interest to Senzo Meyiwa, to
Mr.
our parents,
Mr.
to
Tefo,
our supporter staff.
Mr. Tefo, sit down and allow Advocate Baloyi to continue with what is of interest in this case, which is what I want to hear. There's a ruling for me to make, and time is of essence. I'm saying sit down and allow Advocate Baloyi. This is an interruption, and it is rude, if you ask me. It is a rude interruption, which is unnecessary for our purposes. You are not the only watching brief that was spoken about in this case. There's never been a watching brief here who has interrupted proceedings.
I'm not just watching.
And watching briefs don't address court. On whose behalf are you addressing me?
I am not just watching brief. I've got instructions.
Mr. Tefo, please
So
sit down. If you don't sit down, if you address me wasting time again, I request the court orderlies and whoever is responsible in this court to make sure that you are taken out.
I'm not intending to interrupt this court.
Sit down. Sit down,
What I'm saying
Advocate
is that
Mr. Tefo.
I'm here to bring the submission later. In relation
I
to
told you that I've heard that.
Thank you.
Why must you say it 100 times?
Thank you, Lord.
And when you submit whatever, it will be for me to decide whether I take it.
Definitely.
But I will decide that that has not happened yet.
It will start from there, Your Lordship.
Advocate Baloyi.
As the court pleases, my lord, we have mentioned that our heads of argument are structured as follows. We have already mentioned the introductory part. We then deal with the court process as the second topic. The third topic is devoted to the test that ought to be applied in this matter. And lastly, we deal with the approach of the courts in similar matter. My lord, just to restate the position until now, the proceedings have hitherto been broadcast live, but only with live audio transmission of the evidence of the last two state witnesses. In other words, there were no visuals. We've indicated, my lord, that witness number 1 on the list of witnesses is opposed to the live broadcast of the evidence, be it visual and audio. And we've indicated, my lord, that she has no objection to the journalist sitting in court. Away from the world of glitz and glamour, she is but a witness with vulnerabilities and anxieties for the witness stand. Being a victim of crime is traumatizing, My Lord, we have seen the two previous witnesses breaking down at times. Now, why should this witness be castigated if all that she's asking for is this? She wants to come and relate her story of how she saw the commission of a crime, but she's asking to do so in an atmosphere that is less intrusive. We can mention, my Lord, that there is a service charter for victims of crime that was spearheaded by the Department of Justice and other relevant role players, which, if fully implemented, my Lord, accords victims of crime certain rights and also incorporates minimum standards on services for all victims of crime, irrespective of their social standing. Role players in the criminal justice must ensure that these rights are observed, such as the right to be treated with fairness and with respect for dignity and privacy, as well as the right to protection and so on. We mentioned on Monday, my Lord, that the witness has pointed out to the practice of public scrutiny of evidence of witnesses, comparing the evidence of witnesses who have already testified and criticizing such evidence while the witness is still testifying. We mention in our heads, my Lord, that this is an exercise that the court will eventually have to perform in evaluating the evidence of witnesses at the conclusion of the case. And in our heads, my Lord, we refer to the case of MultiChoice and others versus NPA in the matter of State versus Oscar Pistorius. We've given the citation. And we just want to refer the court to the relevant paragraph 28, where the court remarks as follows: that it has come to the attention of the court that there are media houses that intend to establish a 24-hour channel dedicated to the trial only, and that the panels of legal experts and retired judges may be assembled to discuss and analyze the proceedings as they unfold.
So, I missed the number of the paragraph the counsel is referring to.
It's page 602, my Lord, paragraph 28.
Thank you.
Because of this intention, it behoves me to reiterate that there's only one court that will have the duty to analyze and pass judgment in this matter. The so-called trial by media inclinations cannot be in the interest of justice as required in this matter, and have the potential to seriously undermine the court proceedings that will soon start, as well as the administration of justice. We submit, my Lord, that a witness should be given a choice of whether they prefer testifying in the normal way or in front of cameras. We again, in our haste, refer to what we'll, for sake of brevity, refer to as the Oscar Pistorius case. Page 603 at paragraph 4.5, where the court made the following order: the portions of the trial that may be recorded and broadcast the evidence of all other witnesses for the state, unless, and this is the point that you want to buttress, my Lord, unless such a witness does not consent to such recording, that no such recording and broadcasting can take place. My Lord, the in arguing for the justification of the live broadcast of the proceedings, reference was made to the educational value of showing or carrying the proceedings live. But my lord, there are a lot of cases that take place on daily basis in the lower courts, in the high court, that are not being televised. My lord, cases involving Joe and soap in far-flung areas. Why is there only a focus on cases that are of a high-profile nature?
Is it not because then there is a greater sense of public interest around the case, that there is there are more people interested, and I think the case in point is a perfect example. That it doesn't reside within the periphery of the family interest or even the interest of those who were around when the offense was committed. Scenarios, I doubt whether it will be the best approach.
Indeed, my lord, there is a point that you want to make in the following two instances. Firstly, are there other interests that are being pursued except for the educational value of such proceedings? And secondly, my lord, are they the only cases that have got educational value? What about a case of a poor person in a far-flung area? Isn't there educational value in such cases? All I'm saying, my lord,
is it us? Is it you and me?
Yes.
Is it those of us who are here who can decide what should be regarded, what the general public should regard as having educational value?
Yes.
I think its value not so much as looked at by me and you to the exclusion of everyone else.
Yes. All I'm saying, my lord, is that this aspect of educational value should not be stretched beyond its elastic limits. There appear to be other considerations. I can only take the point as far as that, my lord.
Yes.
We've referred to this case of Pistorius, where the court held at paragraph 4.5 that the portions of the trial that may be recorded and broadcast the evidence of all other witnesses for the state.
You are now on page, on paragraph?
I'm on page 4, my lord. On page 4, paragraph 1.8. My paragraphs have changed slightly, but it's on page 4. We've mentioned that it is important, my lord, that the witness should, the judgment of in the Oscar Pistorius matter properly interpreted implies that the witness should consent to the live broadcast of that witness evidence. Then, my lord, we deal with court process. We mentioned the fact that counsel on behalf of the media has joined issue with the fact that the objection was argued on paper. In other words, it was raised from the bar, as opposed to bringing it by way of a formal application, by way of notice of motion, accompanied by a founding affidavit. My lord, we submit that it is a matter of substance and not even longer to finalize. My lord, we mentioned that there's still a number of witnesses who are still due to testify, and that some of them are likely to request for the exclusion of the live coverage of the evidence, even from police officers who are witnesses. we make the submission with respect, my lord, that it is untenable to suggest that all such objection be brought by way of notice of motion. And I've seen the heads on behalf of media houses, and this very same aspect is repeated there. We make the point, my lord, that such objections can also not be foreseen, as a witness can change his or her mind anytime about testifying in front of cameras, and therefore that the objection must be dealt with as they arise on a witness-to-witness basis. And counsel argued that this is something that should have been dealt with at pit trial. My lord, we submit with respect that, because I think counsel for accused number 5, we mentioned, my lord, that that is not something that can be foreseen. It can arise, as in this instance, on the eve of the evidence or the witness giving evidence. And at paragraph on page 5, we mentioned that there was an application that was brought by the SWAL counsel for accused number 1 and 4 for the exclusion of parts of the media and 1010 producers, which was also argued on paper. We submit, my lord, that in light of the fact that this is going to be a long and protracted trial, the court is entitled to devise quicker and convenient way of dealing with all the issues that arise during the trial. This court has got inherent powers to regulate its own process, as envisaged in section 173 of the Constitution. And we refer to the Van Breda case, my lord, that was extensively referred to on Monday, where the court held as follows: the trial process, already time-consuming and expensive, must not be allowed to become further unnecessarily protracted. Then, my lord, next we deal with the tests to be applied. At issue in this matter, it's a clear contestation of rights. The nub of this matter is about the balancing of the right to privacy of witness number 1 against the right of freedom of expression when considering the exercise of the media freedom of expression in the courtroom and the right to a fair trial. All come to the fore. We submit, my lord, that it must therefore be ensured that the interests of justice are upheld. And in the Oscar Pistorius matter, this concept of interest of justice, the court held at paragraph 17 that it does not only relate to an accused person, right to a fair trial, but also to the prosecution's right to the same right, as well as all other interested persons' rights in the same proceedings. And in that case, reference is made to the Constitutional Court case of State versus Lameni. We give the citation there, wherein the court said this concept of what is a fair trial denotes in broad a value judgment of what will be fair and just to all concerned. And the court went further to hold on that the right to a fair trial suggests that freedom of expression rights to which the applicants lay claim should be attenuated, and that the open justice principle should necessarily suffer the same fate. It is inevitable that in the exercise of the Balancing Act, as well as the powers found in Section 173, the rights at issue in this matter will be limited in one way or the other. The approach to ensuring that each right find expression and the extent thereof was articulated in the media television case that my learned friend on Mr. Rosengarten on behalf of media houses referred to on Monday. We give the citation and we refer, my lord, to paragraph 9 thereof, where the court held as follows: where here constitutional rights themselves have the potential to be mutually limiting, in that the full enjoyment of one necessarily curtails the full enjoyment of another and vice versa, a court must necessarily reconcile them. They cannot be reconciled by purporting to weigh the value of one right against the value of the other, and then preferring the right that is considered to be more valued and jettisoning the other, because all protected rights have equal value. They are rather to be reconciled by recognizing a limitation upon the exercise of one right to the extent that it is necessary to do so in order to accommodate the exercise of the other, by recognizing an appropriate limitation upon the exercise of both rights. In paragraph 3.3, my lord, we have already referred to the Oscar Pistorius case, wherein at paragraph 71, the court held that it remains the duty of the trial court to examine with care each application, that court should exercise a proper discretion in such cases by balancing the degree of risk involved in allowing the cameras into the courtroom against the degree of risk that a fair trial might not ensue. Paragraph 3.4, my lord, we refer to what the court held as a tension between the right for freedom of expression and the open justice principle on the one hand, and the rights to a fair trial, and that those rights should, as far as possible, be harmonized with one another. My learned friend on Monday referred to the need for the court to determine whether there is demonstrable risk that a certain prejudice will occur, and that mere conjecture and speculation that prejudice might not occur ought not to be enough. We refer to paragraph 17, where the court held that the right to a public hearing does not automatically mean that trials must necessarily be broadcast live in all circumstances. And my lord, as we've indicated that there are many trials taking place in the country, it is by way of exception that you have a trial being televised, as in the current situation. It is therefore our submission, my lord, that we need to tread very carefully if a witness says they are uncomfortable to testify in front of cameras. And my lord, this brings into sharp focus the role of witnesses in courts. When giving evidence, witnesses perform a public duty. A witness performs a civic duty when he or she comes to court to testify about the commission of a crime. Witnesses help the courts to resolve the disputes that serve before them. And we submit, my lord, that witnesses therefore need to be accorded courtesy and respect, and that their reasonable needs need to be accommodated. Others witnesses will be deterred from coming to court to testify. And we've already mentioned, my lord, that as a starting point, no witness should be forced to testify in front of a camera. If a witness says they are uncomfortable to testify in front of a camera, we submit, my lord, that alternative ways should be explored. We submit with respect, my lord, that the right of the public to be informed of court proceedings can never trump the right of a witness to testify in a way that is comfortable to him or her.
By alternative means, what are you referring to?
My lord, for instance, we suggested to Mr. Rosengarten that the evidence of this witness can be recorded and then shown at the later stage when the witness has already finished testifying.
Is that not what Mr. Rosengarten spoke about?
No, he was only referring to the visuals, not to the sound recording.
Okay.
My understanding is that he's opposed to the to the fact that the witness evidence be recorded, albeit only via sound and then shown at the later stage. I think he went on to argue that during current affairs program, then the visuals can be shown. And this is what he's also asking for in his heads, that the court should go further and order, contrary to what has been the practice now, that even visuals should be recorded to be flighted at the later stage. We submit, my lord, that there's no reason to interfere with the current practice where the proceedings are shown live, but if a witness says, for security purposes, as with the past two witnesses, if they say, please, I don't want my face to be shown, that there's only sound recording. We submit, my lord, that there's no reason to disturb the current arrangements. My lord,
are you saying that the visuals emanating from that process should remain out of reach to posterity? That it doesn't matter how long after the conclusion of the trial, that they remain forbidden from being broadcasted?
Well, my lord, after the conclusion of this case, there shouldn't be any objection to to that material that has been archived to be used for educational purposes. My lord, we point out that the live broadcasts of court proceedings has also its own disadvantages. It is not as if, my lord, it's a panacea to witnesses who cannot come to court. It's not a panacea to open justice. The live broadcast of proceedings have got this distinct disadvantage, my lord, in that witnesses who might still testify might watch how witnesses before them testify, how they are treated. We therefore submit, my lord, that it is not a panacea to informing the public of court proceedings. We, as I've already mentioned, that recording the evidence and showing it and showing the evidence after the conclusion of the case is another way of informing the public of court proceedings. And this will in fact ensure that no witness who's yet to testify can watch the evidence of witnesses who testify before them or become apprehensive as to how such witnesses are treated. In the Van Breda case, at paragraph 73, it was even suggested that in other instances, broadcasts of testimony of an objecting witness could be delayed until after the trial is over. This is what we have just submitted. My lord, we submit that witness number one harbors a reasonable apprehension that harm might befall her. It cannot be said that such harm must first eventuate to demonstrate that there's real risk of harm occurring. We submit, my lord, that it is about a reasonable belief held by the witness. And we mention here, my lord, that if a witness is expected to testify about such belief or submit an affidavit as suggested by counsel for the various media houses, the court might be called upon to make a finding about the credibility of such a witness before the witness has even testified. We therefore submit, my lord, that arguing the matter on paper is the correct approach. Then the fourth topic, my lord, we deal with the approach of the courts. We have already mentioned that in the Pistorius case, the court held that or implied that the witness must first consent to the live coverage of his or her evidence. We've already referred to the court's power to regulate its own process. We're not going to repeat it. Perhaps lastly, my lord, I think the rest of the paragraphs have already been dealt with on Monday, pages 9, 10. We have already dealt with that, my lord. We're not going to repeat it. Page 11, that has already been dealt with. Then the last aspect, my lord, it's the point that was raised by counsel for accused number 3 and as well as counsel for the various media houses. But in particular, my lord, counsel for accused number 3 argued that the first witness has already participated in the making of a documentary which was flighted on Netflix, which depicts events that led to the death of the deceased. We had a discussion this morning, my lord, with counsel for the media houses, and we are agreed, my lord, that first witness did not participate in the making of that documentary. And they would know better as he represents the media houses. And we also have an affidavit to that effect from this witness that she did not participate. We other counsel indicated that they will object to the handing of the affidavit, We therefore leave it at that, my lord, that counsel for media houses and the state agreed that she did not participate in the making of the documentary. The only other aspect that remains is her participation in the interview by ENCA. Here, my lord, we submit that it needs to be mentioned that ENCA was in breach of the sub judice rule in so doing, as this case was pending and the witness was yet to testify. We also submit, my lord, that an interview is also controlled. A set of questions are sent in advance and can thus never be compared, my lord, to testifying in court. We therefore submit, my lord, that the objection of the witness to testify before cameras should be upheld. This is as far as we can take our argument, my lord. I don't know if there are any other aspects.
Just before we adjourn for tea, the one short question I have, there was reference on Monday to, let me not say reference, there was an allegation on Monday made by one of the representatives that even as we were debating this aspect of the broadcasting of proceedings in this case, the applicant was active in the social media, communicating, as it was alleged, far and wide about her take to this case. I didn't get into asking the details of what was being alleged, but the long and the short of it was that she was, the applicant was communicating on social media and therefore placing herself out there for the very criticism that she now sounds to be apprehensive about.
Yeah, well, my lord, regarding social media, I think debates that occur in the platform, I don't know whether those debates can be put before this court. We know what the nature of social media is, but
no.
During the
we're not talking about social media, yes, in the wide sense.
Yes,
we're talking about social media to the extent that the debate is triggered by the applicant herself.
Yes.
I think that will be different from where,
yes,
somebody may be watching, as they may be now, and they decide to run a debate, some I don't know, I'm not active in that,
yes,
in that periphery, and whatever happens there, there may be talks going up and down around it, because they are watching and they are observing, they have opinions, they have ideas, they have objections, which are irrelevant for our purposes. But here we are saying, they were saying, here's an applicant who is represented in court by the state, who is saying, one of the reasons why I do not want the beaming of visuals and the broadcasting of audio proceedings in this case is because it will bring me into focus before the members of society, and it will render me liable for criticism and scrutiny. That it sounds like a contradiction, in that the very same person doesn't want society to be at this stage debating about what she did say or do or did not say. But then at the same time, that person is placing herself out into that very field where, without choice, somebody will respond, react, object, or whatever will happen.
As a court, please, perhaps we can take the short adjournment. We'll then deal with this issue when we resume. My Lord, the only submission we can make in regard to the point that the court raised is that there was an onslaught against her in social media and that she was merely defending herself against such onslaught. That is as far as we can take the matter, my Lord.
It doesn't for me, it doesn't settle the matter. She's saying when there is an onslaught against me on social media, I can defend myself. At the same time, she's saying there may be an onslaught against me in social media and elsewhere. But for that, I want the court to employ measures to defend me.
But we, as we indicated, my Lord, our submission was that if there's a live coverage, then there will be a total onslaught against her, and that might affect her in continuing with her, her testimony. At this stage, my Lord, she hasn't taken the witness stand.
She has?
She hasn't taken the witness stand, but if the onslaught goes on while she's testifying, my Lord, that will have the effect of dissuading her to continue with her evidence, my Lord. That's as far as we can take this point.
Mr. Advocate Ramsipi, I am in possession of your written heads on behalf of accused number 1 and 2. I'm just checking whether you have anything to add, and then it should be adding.
I may have something to add, but it's agreed amongst us that my learned colleague, Mr. Rosengarten, go before us, my Lord. Then ours will be just short submissions, if there are any.
Mr. Rosengarten,
as the court pleases, my Lord.
Our understanding from Monday was that you have already addressed, you have now submitted heads, and you might, and I think even this morning you reiterated that you might want to add a thing or two to both the address you made and the and the written, I mean, the address you made this morning and the written heads you have now placed before court.
Indeed, my lord, you have my heads of argument. It substantially summarizes what I argued before you on Monday. There are one or two nuances I want to deal with, and a suggested court order appears on the last page of my heads of argument, but I shall get to that in due course. My lord, my submission today will consist of two parts. The one is various general comments relating to the matter, including some developments which have happened since Monday. The second part is to answer in brief the contentions from my learned friend Mr. Baloy, both contained in his heads of argument and as presented today. Now, my lord, the be-all and end-all of the matter, and need not go any further than this, is that to date, the witness number one, who is well known, she is plastered all over social media, and indeed there is a picture of her standing at the lifts, which I believe are the lifts in court. And I have a copy of that picture, should my lord require it.
Yes?
An application of the sort from the bar without evidence has absolutely no foundation whatsoever. It's not common practice, my lord. Even an application for discovery is on affidavit with evidence. Evidence from the bar does not even constitute hearsay. And even so, there are just generalized points like she feels fearful for her safety. There's no evidence to say why she feels fearful for her safety. So that is the be-all and end-all of the matter. Now, my lord, for the first time on Monday, I raised the point...
Before you go there,
yes.
I think in considering what you are saying, we also do have to be realistic. This is a real incident from which a real death ensued, and we now have a real trial underway, and we are calling real witnesses to the witness dock to say, to give evidence, and under cross-examination to defend the way they put their evidence before court. And this triggers perceptions. This, of course, she herself has already used the word scrutiny. It puts her out there for scrutiny. I hear what you are saying, that we have not been given evidence which lays out the modality of the ongoings she is apprehensive about. But we cannot at the same time that pretend as if what she is required to do in testifying is just like a walk in the park. She is in an unusual position. She is to testify about an emotive issue which is real to people to differing degrees. So much as I hear what you are saying about no evidence being on the table, I think we should be wary of that, because that is reality. I can almost take some particular notice of the fact that she is in a particular position. When all is said and done, even today, or even now as we are sitting here, there are people who are talking about this case. They are not talking about the other many cases that are happening in the world, but there are people among them, soccer lovers, sports lovers, family members of everyone that is affected, even family members of journalists that are here. Everyone is talking about it. That we can rest assured is happening. So I just needed to say that, not that I reject the point you are making, that the way this request has been brought before court, the court has to apply its mind and apply the law to it.
As the court pleases, and I'd like to address that since you've raised it directly, and I have several points to make in that regard, in no order. And my Lord, if you will just bear with me, there is a quote which my learned... No, there is a quote in my learned friend's heads, and I deal with the point.
Yes.
About the huge public interest in this
and
matter.
That point is on paragraph or page?
It's paragraph 4.1. There are no page numbers. It's under the heading, the approach of the courts.
4.1, yes.
And I make this in relation to the fact that the matter is trending. Everyone is talking about it. It's the death of a legend. It's a death of an athlete, which of course puts it beyond doubt that the matter is in the public interest. Now that point supports our case, my Lord. It's everywhere. Everyone is talking about it. Social media is ablaze with it. There are pictures of witness number one. Everyone knows she's the person who's bringing this application to have it heard in camera. And the nearest example of this, my Lord, is the Pretoria matter. It's referred to as the multi-choice matter. And my Lord, my learned friend, deals with it in paragraph 4.1. So I'm not quoting from my heads, I'm quoting from his. And he emphasized it. And I read halfway through. And bear in mind, this was also a South African athlete who was an absolute icon. The killing of Ms. Steenkamp and Mr. Pretorius' subsequent trial inspired articles, informed television programs, and clogged social media for months on end. No different to this matter. And then he goes on, at the end of that paragraph, Malumbo JP, despite all this and in these circumstances, allowed the media to broadcast audio recordings of the full trial and to televise part of it. My Lord, my recollection is Mr. Pistorius objected to having his image televised and only wanted his audio, or there was a ruling that only his audio should be broadcast. But in any event, as it transpired, and you'll recall from the matter, the evidence of Mr. Pistorius, including his image, was broadcast. Now, my Lord, and I repeat the point, we don't know why witness number one is scared. There is nothing. Has she been threatened? Has anyone phoned her and said, well, if you say X, Y, and Z, we're out to get you? There's nothing. We've just got a bland statement. She's scared. Now, insofar as evidence is concerned, I first raised this on Monday. Today is Wednesday. Just short of 2 days, because I started to argue at 2 o'clock. In that time, it was quite open for Mr. Baloyi to get a letter, to get an affidavit, to get anything from this witness. But more startling is that Mr. Baloyi did get an affidavit from this witness, and that affidavit, which was deposed to today, merely deals with the fact that she does not appear on the Netflix program. Why did she not add a page? Say, I'm scared of testifying live on by means of a broadcast because I have been threatened. Very easy for her, my lord, and I'm not sure if this affidavit has been handed up to you, but it is dated the 17th of May, 2023, being today.
It's dated what?
Today's date, 17 May 2023.
Yes.
Now, my lord, last year, the witness made the following post. I have it on my phone, but I will make it available to you one way or another, should you so require. And it's a very important post, because it reveals a lot about this witness and why she does not want to testify, and whether it's really about the reasons my learned friend posited both in argument and in his heads of argument. And if I could read this post, which has had 2,172 likes. After work, I had a late afternoon nap and had a dream where we as a family had decided, Ukuti, we don't want any media present in court when we testify. Not even our voices should be heard. So we don't want to waste any more of the people's time. Since it says SI, guilty already in their eyes, so we rather testify to the court alone, since they are the only ones who haven't found us guilty. And the court said, granted, my biggest fear is that my dreams always come true. Well, this witness has brought this objection based on a dream. She says nothing about fearing for her life. And my lord, I pause to say and to ask whether this is merely a publicity stunt for someone who is very active on social media and whose image is all over social media. Then, my lord, there is a second post. This one is dated Monday, 15th of May. And bear in mind, 15th of May was when this application was brought. And it was brought, I think, after my learned friends for the accused had presented their argument, because the post is at 12:42, and again, unfortunately, I only obtained this now and can only read from it, but will make it available to you. It looks like one is never going to get their day in court, because people
you say at 12:42?
At 12:42,
okay.
On the 15th of May. It looks like one is never going to get their day in court, because people entrusted with this case have turned into a circus. So I might as well say this here and now. It really pains me that this case doesn't look like it will be solved anytime soon, because South Africa believe opportunities and populists like this one. It pains me because it means the Meyiwa family will never get justice, and because it means my family will forever live under this dark cloud. This one claimed he had eyewitness. He claimed he had proof that Kelly pulled the trigger, and now he withdraw this. He has had his 2 minutes of fame. This desperate desire to find the Kumalas guilty. So we will believe and back anyone who says what we want to hear will stand in the way of justice. This tunnel view approach that society is applying to this case is what is obstructing justice from being served. Now, this is someone who fears to testify. It cannot be so. It cannot be so if these are the comments she's making on Monday, if she's telling us about her dreams, that she wouldn't have her evidence live on television. Moreover, my lord, while I hear your questions, it is not the law. And perhaps, my lord, in this regard, and it was in my argument anyway, bear with me, my lord, I can again take you to the seminal case of Van Breda. And my Lord, I don't go into any detail, but I will refer you to the relevant paragraphs in my heads of argument. At paragraph 9, I present a quote from Van Breda. And the conclusion is in paragraph 10 is that the default position is that witnesses do give evidence, not only audio evidence, but broadcast camera evidence. And I repeat this from Monday because it is so important. And the person seeking such limitation bears the onus to justify this with evidence, not mere conjecture as to why such limitation should be put in place. And that's paragraph 75 of Breda. And what do we have, my Lord? That is the default position. That is the law. There is no evidence. They need to present evidence. It is mere conjecture, given as it has been from the bar. Then, my Lord, if I can take you to sorry, my Lord, my pages are sticking. Paragraph 16 of my heads, in which I deal in some detail with the case in Van Breda, the case of Van Breda. And again, I emphasize the relevant part. It is only if pertinent evidence has been led in this regard. Evidence. And evidence doesn't mean, as my learned friend put it, on paper, meaning from the bar. It is real, it is hard evidence. And my Lord, in relation to this point, I think there's been a misunderstanding. It is no expectation that each application for a particular witness be on notice of motion supported by affidavit. The practice in that regard is the witness comes, whether in chambers or otherwise, with all interested parties or in the witness box, and says, I don't want my image broadcast because I'm camera shy. And then you look for the least restrictive method, as per Van Breda, of which audio is one. I then take you to page 18 of my heads, and in particular 18.2, where Ponnen J.A. held that witnesses may object to their testimony being broadcast and will be required to set out the grounds for their objection. And in 18.5, an objection by a witness will only justify the restriction of the nature and scope of the broadcast if the prejudice is demonstrable. So, my Lord, in fact, by answering your question, I've dealt with a substantial portion of the first part of my argument. The conclusion of which is the matter can go no further. An application from the bar without evidence cannot be granted. Indeed, my Lord, I would suggest that now we have taken 3 days, that this could have been done half an hour by the witness or my learned friend presenting an affidavit to you, which would be dispositive of the matter, subject to other interested parties having the right to deal with it as well. And so, my Lord, when I do refer to notice, and it's dealt with in the order I would suggest, the notice I mean is that if there is to be an objection to a witness giving evidence, then all interested parties should be given notice. Not notice of motion, but notice to say, well, tomorrow witness number 1 is going to object to having her testimony broadcast live. That would prevent certain delays, because I could be given notice on behalf of the media or anyone representing me, as well as the representatives of the accused. And rather than delaying the matter by having to get someone, whether from Pretoria or Johannesburg, we would be here in advance of the matter. Then, my Lord, if I can briefly turn to my learned friends, certain of my learned friends' argument. He posits, and these appear in his heads of argument, at paragraphs 1.1 to 1.6. Sets out the grounds why witness number 1, her testimony should not be broadcast live. And there, the points are several. 1, mere speculation, mere conjecture, evidence from the bar. 2, if there was such anxiety, if she did not want her witness, her evidence to be broadcast, if she was scared, if she feared she would be open to ridicule, then, my Lord, the application by my learned friend would have been a different one. It would have been an application to have her evidence heard in camera. Because members of the press, they're all here. They're all taking notes. Everyone is tweeting. Everyone knows what this case is about, and it is reported on every day, including yesterday or the day before concerning this application. She wouldn't have wanted everyone behind me sitting in court, of which there are many, and there could be more. She wouldn't have wanted them in court. My Lord, just give me a minute to go through my learned friend's argument, because I have already dealt with certain of it while addressing you in response to your various questions. We've dealt with the principle of, if one doesn't want to be televised, there's always the possibility of an audio link. We've dealt with the Pistorius matter. And then merely turning to one or two things which my learned friend Mr. Baloy spoke about today. One of the issues he raised was the need to balance rights. And we agree that that is the position. One does need to balance rights. And you, my Lord, are the arbiter of those rights. But that cannot be seen in isolation, as pointed out by Bredar. This is always subject to the default position, and once again I refer you to paragraph 72 of Bredar, which I quoted to you earlier on today as well as on Monday. My learned friend also said televising a trial is by way of exception. That is factually not so. Many trials are televised. Whether they're all live or not, that may or may not be the case. In any event, even if this were the first trial to be broadcast live, as was the Pistorius trial, the default in Van Bredar applies. And my Lord, there's no evidence as to why the testimony should not be live but rather delayed. My Lord, regarding the ENCA program, the sub judice issue, there's nothing for debate there. I think my learned friend makes nothing of it, but in any event, the Mamapolo case decided in the Constitutional Court deals quite clearly with issues relating to the sub judice rule, particularly in our system where there is no judiciary. Then, my Lord, finally, if I could take you to paragraph 39 of my heads of argument, which appears at page 19. It's in essence the last 2 pages. And it appears that there may be some confusion regarding what members of the media through me are asking for. And I take full responsibility for that. So what I've done is I've encapsulated it in respect of what the media wants and what we believe the way forward should be, not only in respect of the media, but for the accused as well. So if there were to be an order, it would be as follows. 39.1. The state's application to prohibit members of the electronic media from filming, recording and broadcasting the proceedings on a live basis be dismissed. Sub 2. Members of the electronic media be permitted to film, record and broadcast on a live or delayed basis, in whole or in part, the testimony of the witness, and that the filming of the witness's image not be broadcast until the end of the trial. In other words, the audio goes out live, the witness is filmed, archival purpose or for current affairs program. 3, which is what I touched on in terms of the notice rather than notice of motion. Any future objections by a witness to having his or her proceedings filmed, recorded or broadcast should be based on evidence, whether in the form of oral testimony or otherwise. 4. To avoid the delays my learned friend anticipated, such objection should be delivered 24 hours before the witness of the testimony. And 5. Notice should be given to every party, and to avoid objections being heard in open court, every attempt should be made to resolve these in chambers, and only if they cannot be resolved, a hearing in open court where all interested parties are entitled to make submissions.
Doesn't 4 suggest that everything in life is predictable?
I didn't.
Everything in life is predictable. I mean, I would think that given certain circumstances and eventualities, 4 would be too absolute.
Yes, my Lord, and perhaps one could temper that by saying every attempt shall be made. So it's not a hard and fast rule. Every attempt shall be made.
Okay.
And lastly, it was also every attempt shall be made to have the matter resolved in chambers. Alternatively, a hearing in open court in which all interested parties are given notice and are permitted to be heard, and this includes members of the electronic media. My Lord, subject to any further points of clarity you want, those are my submissions today.
Just to make me understand, because your 39.1 suggests a dismissal of the application, but the body of your suggested order seems to concede that there are certain considerations to be made out of the request made, albeit not in total.
Yes,
to say that it is dismissed and then to say what follows, is that not a contradiction in terms? Does that not mean that if this reasoning were to obtain, then the application will have succeeded, albeit in part, however minimal that success may be?
My Lord, I'm not sure in which part the application would be successful.
The applicant requires that certain limitations be put in place in terms of what members of the media can and cannot do. What we even said on Monday, that she wants more than what other witnesses were afforded, in that with other witnesses there were restrictions in place, although it was around the beaming of their faces in a public broadcast. And this applicant comes, if you read through her submissions, she is under the impression that once she comes, there will be a wholesale broadcasting of what she will be adducing from the witness doc.
Yes, my Lord, that is the very point which I made during my argument. It is precisely that she has shown no reason, no evidence. It's bland speculation from the bar as to why the default position, which includes televising the image of witnesses, should not be applied. The onus is on her.
Is that a shift from what you said on Monday?
It's not a shift. The onus remains on her to lead evidence as to why her testimony should not be broadcast live. And my Lord, if paragraph 1 were to be in place, read with paragraph 2, and perhaps I should have divided paragraph 2 into 2 portions, what we want is the application not to have the evidence of this witness broadcast live, even on an audio basis, is dismissed. And the corollary of that is that the electronic media be permitted to televise, record, and broadcast her evidence on a live basis, even by means of audio.
Okay.
My Lord, you still seem uncertain, and if there's anything I can do to clarify that.
Yeah, I'm just mindful of the point at which we ended on Monday, taking into consideration what happened to the last 2 witnesses. And like I'm saying, she presupposes that, and it seems to be what you are arguing, that she should just come and testify, and everything that the media feels like getting up to in terms of the broadcast should be allowed to happen, because she has not tendered any evidence. And the last 2 witnesses did not tender any evidence. We took into consideration the enormity and the nature of the case, and also we learned from an incident that happened as trial was unfolding, and we put measures in place to make them more comfortable about the exercise they were to engage into in court. Now, like if you listen carefully, I'm triggered by the reading, the literal reading of paragraph 1 of your suggested order.
My Lord, perhaps then I can leave the order at paragraph 1. Paragraph 1, my learned friend has applied for the exclusion of electronic media, not from being in court, but from recording or broadcasting on a live basis the testimony of this witness. And I ask that the application be dismissed. The first 2 witnesses, they didn't object. And all we ask is that the matter proceed as it did with the first two witnesses. To dismiss, well, to accept the application from my learned friend, which is not based in any fact, but is a dream, my lord, I would submit that cannot be accepted by you.
What would you regard as maintaining consistency if we were to look at how the last 2 witnesses featured?
My lord, I wasn't present when the last 2 witnesses gave evidence.
I think it has come out.
Yeah, but what I understand is that the witnesses' faces, their identities were not revealed. Their testimony was broadcast live by means of audio. At the same time, there were visuals of the court. And that is all we ask for. If you're disinclined to allow us to keep any footage...
No. All I'm getting is clarity from you. And I keep on repeating, looking at the word dismiss, which you used in I think you have now come to say that you are not necessarily glued on the reading of clause number 1 of your suggested order.
Yeah. My lord, I suspect it's poor drafting. I had a short time to prepare the heads of argument, so really perhaps one could state it the opposite way, that we seek an order, we being the members of the media, radio and television, we seek an order to continue and to be allowed to to broadcast the evidence of this witness, much in the same way as the previous 2 witnesses, live by means of audio and cameras to be focused on court, but anyone but the witness. That is all we seek. The rest is to be given notice. We don't need that as part of the order. Hopefully everyone would have learnt that rather than delay matters for 3 days, that will be the case.
Okay. Yeah, I think.
As the court please.
Mrs. Malot, without adding anything further, I think just on the last point, the debate with my learned colleague, Mr. Rosengarten, with respect to dismiss or uphold, I think the element missing there was further and or alternative relief, so that instead of dismissing, we come up with an alternative relief, my lord.
I didn't seem to come through to Mr. Rosengarten, but what you are suggesting now doesn't give me the same challenge as how it is. But be that as it may, he has indicated more than once that he is not necessarily glued to the reading of clause 1, and I'm debating it with you for my clarity. I'm not suggesting at this stage that it is what I'm inclined towards. Also that it sounded to me to be a bit of a shift from where we ended, because subject to all the 4 of you correcting me, my understanding when we ended on Monday was that in view of what we saw happening with the last 2 state witnesses, the four of you are objecting to the application made in no particular degree of intensity, but you are dead opposed to restrictions going to affect audio and audio broadcast of these proceedings, much as you would be dead opposed to the whole proceedings being open for beaming, albeit after the conclusion of this trial.
Indeed so, my lord. As the court pleases.
As it is the court, my lord, but not so much to say. And at this point, if I have suffered to make disappointing legally, I think it's paragraph 2, that should be paragraph 2 of my heads of argument. I wasn't part of the trial at its very inception, so I may not know whether the pen or what was then argument with regard to how these proceedings will be televised. I'm not even so sure, my lord, whether there was an order in that regard. But subsequent to what happened to Mr. Madlala, and I've heard this from my colleague on Monday, but at some stage he had to come to court and address certain issues. I'm not so sure whether subsequent to what happened to Mr. Madlala, in the course of his testifying, then there was an order that gave directives as to how henceforth or thenceforth the proceedings in this case should then be handled.
What happened after the incident involving Mr. Madlala is that the witness expressed intense apprehension around not only testifying but also around finding himself within the courthouse and moving around, and that was triggered by how the members of the press were I don't want to say treating, were behaving in his presence. And it from what we were made to understand, it culminated in a real run for cover on his part down the passages with a journalist with cameras following behind him, and that gave him not only a fright but a general apprehension about his role in the case as a witness. We subsequently addressed that. We even got together with members of the media and the court management. We even brought into place a measure of checking who gets and who doesn't get into the courtroom, and it did not culminate in a specified order, court order, but we had an understanding of how everyone shall behave themselves whilst this trial lasts.
Yes, it is a court. Then if that is the situation, then my argument is gets to be a neutral argument because it does not take the matter any further, except to say that I would still continue to stand by what I've submitted in the other parts of my heads of arguments, madam. Thank you.
Thank you, my lord. My lord, I will abide by my written heads of arguments. I have nothing further to add. Thank you.
As the court pleases, my lord, I'm intending not to be long. I'm also intending not to repeat what is contained in my heads of arguments, my lord, but I'll just highlight few points and refer this honorable court to few paragraphs in the judgment of the judge president in the case of Pretoria, in which the state has referred to this court to. But the citation is multi-choice, my lord, multi-choice limited, combined artist production and media broadcasting versus the NDPP and Oscar Pistorius. My lord, I'll be very brief because I have included my first point in my heads of argument. To say, my lord, the state ought to have brought a substantive application, my lord. The reason why I'm repeating that submission, my lord, it's because the state has failed to place before this court
Sounds like a finding.
no, it's not a finding,
Okay.
my lord.
Yeah.
Has failed to place before this court the circumstances, the nature, and the extent of the relief sought or of the objection raised. We don't know to what extent will her constitutional rights be affected, my lord. And accused number 5, my lord, had been prevented from responding to such an application by way, my lord, of putting in an answering affidavit the reasons together with the evidence supporting his objection, my lord, to the application that is before court. My lord, I understand it has been submitted by the state that due to the unforeseen circumstances, this issue, the state only became aware a night before we started this case, my lord. My lord, it is my submission that that does not allow the state to hijack this court with this type of an application, because there is a process, my lord, wherein the state could have brought this application on agent basis. The process is called or is referred to as an agent application. That process could have been brought overnight, wherein all affected parties could have been cited.
Yes.
The state ought to have followed that procedure, my lord, because this court right now is expected to rule and interfere, my lord, with the constitutional rights of the public, of the society at large, of the accused families, local communities, South African communities, as well as international communities. Their constitutional right is at stake as we speak, my lord, wherein the application is brought to deny them access to the live recording or live audio or recording, as it has been stated, my Lord. My Lord, we, as I'm representing respondent number 5, my Lord, we cannot be able to refer this court to the screenshots and any other type of evidence. We ought to have done that by annexing, my Lord, those screenshots and any other evidence into the opposing affidavit for the presiding officer who is dealing with this matter to read and have access to those information. My Lord, we now being forced to address to testify from the bar, my Lord, to say the witness or the applicant who is seeking protection not to have her evidence recorded is the one, my Lord, who is busy discussing with this case on the media. And I'm not supposed to be addressing His Lordship on this issue without the evidence being put on paper. Right now, this morning, my Lord, the state wanted to bring or to submit the affidavit, which is alleged to have been signed by the same applicant. And then I said, how on earth can you do that? We don't submit the evidence in this way, my Lord. This ought to have been put in a founding affidavit, my Lord. Even if it was not a founding affidavit, but if an affidavit and a sworn-in affidavit from the applicant stating all the facts, the circumstances, the nature of the relief sought ought to have been placed before this court. My Lord, as I said, let me move on because I've included this point in my heads of argument. I just wanted to highlight, to say there is a process, there is a mechanism which ought to have been followed by this court. And my Lord, this is not the only witness who is available in this court. The state ought to have brought a substantive application, whether on agent basis or in the normal way, in the motion court, and proceed, allow this trial to proceed, my Lord, with other witnesses. This is not the only witness, my Lord. The other court would have been seized with an opportunity to deal with this matter while this trial is not delayed for flimsy reasons. The procedure and the process is flawed, my Lord. However, my Lord, I do understand that this court has got an ultimate discretion to deal with this matter. However, and also it is my submission, my Lord, that in doing so, this court should consider the interest of the community as large as I've just alluded or as just submitted. I'll ask also this honorable court, my Lord, to consider the provisions of Section 16 of the Constitution, which guarantees everyone the freedom of expression, which includes the freedom of the press and other media, as well as the freedom to receive information and ideas. My Lord, with the leave of the court, may I just refer this court to paragraph 21 of the Oscar Pretoria's judgment, in which the state has referred this court to earlier on. I'll just read it quickly, my Lord, because it's contained in the judgment, my Lord, which I've also referred to in my heads. My Lord, paragraph 21, I read open quotes. This is the judgment, my lord, by Mlambo JP. Can I read, my lord?
Yes.
Thank you, my lord. Paragraph 21. I'm not persuaded that objection by Pistorius to the coverage of this pending criminal trial should be jettisoned to the extent he suggests. I have found merit in the argument on behalf of the applicants that asserting to the objection by Pistorius will fully perpetuate the situation that only a smaller segment of the community is able to be kept informed about what happens in courtrooms because of this minority access to tools such as Twitter. Acceding to that argument will also perpetuate the reality that the community at large remains dependent for news on what happens in courtrooms from the summarized version of the journalists and reporters who follow the proceedings. My lord, my emphasis is on the following sentence.
You said that's paragraph 21.
Paragraph 21, yes, my lord. My emphasis I want to refer to this court, my lord, is on the same paragraph which says, these summarized versions or accounts have, in my view, been correctly categorized as second-hand, liable to be inaccurate, as they also depend on the understanding and views of the reporter or journalist covering the proceedings. So my submission, my lord, is that if the audio recording is not granted, my lord, then it means the society, the public, will receive what is referred to by our judge president as a second-hand information from the journalist who will be lucky to have seats in this court, so that they can only be able to relay to the society after that information. And the judge president summarized that that process is liable to be inaccurate, as they also depend on the understanding and the views of reporters and journalists. So in other words, my lord, the right to direct access to the court proceedings of the society at large will be affected, because now they will be receiving it from the journalists and from the reporters. Sorry, Rosa.
Yes.
So the right, the constitutional right of the society, my lord, to have direct access to the court information, live proceedings will be affected, because now they will have to rely on the inaccurate information received from the reporters and journalists.
Yes.
My lord, it is also important to take cognizance of the fact that Section 34 and 35 of the Constitution make it very clear that even criminal proceedings in this country are to be public. Therefore, my lord, it is my submission that the proceedings before this court, whilst the witness is testifying, should be made audio recording should be granted in that respect. My lord, also, I will ask to refer this court to few paragraphs 25 and 27 of the same judgment, my lord, of Mlambo JP. My lord, this paragraph refers to the balancing of the competing rights. As we have, as this court is faced with that duty as we speak, balancing the competing rights, my lord, meaning that one of an individual who is the applicant and that one of the society at large, as I have described the categories of the society affected. With that, my lord, I'll then move to the 5th line of this paragraph. Wherein Mlambo J says, my lord, I quote, "For this reason, I'm of the view that the audiovisual or televising and..."
That's paragraph?
Paragraph 25, my lord.
Yes.
Line number 5, my lord.
Yes?
The one that starts with "for this reason."
Yes.
Thank you, my lord. I quote, my lord, "For this reason, I'm of the view that the audiovisual or televising and still photography of Pistorius and his witnesses when they testify be disallowed, and this has the potential to deprive him of a fair trial on the grounds spelled out in the argument on his behalf. I am persuaded that there is merit in his fears and that of his witness that they may be disabled somehow in giving evidence." This is a different case that we are sitting with, my lord. Mr. Pistorius had elaborated and placed evidence before court in an affidavit, my lord, stating what made the court to come to this conclusion, which is not the case in this court. Other than speculations, with due respect, my lord, I submit. And therefore, my lord, it is my submission that this court has been less empowered with the tools of being able to reach or to come to a just and fair decision.
Yes.
Paragraph 27, my lord. I will be quick, my lord.
Yes.
Regarding the fears also raised by the applicant, my lord.
Yes.
This is how Mlambo JP responded to the fears of Mr. Pistorius, my lord. Paragraph 27, I read open quote, my lord. "I further consider the extensive interest that the pending criminal trial has evoked in the local and international communities as well as in media circles," which has also been my submission, that the court should consider the interest of these international communities. My view is that it is in the public interest that within allowable limits, my lord, the going on during trial be covered, as I have come to decide, to ensure that a greater number of persons in the community who have an interest in the matter but who are unable to attend these proceedings due to geographical constraints, to name just one, are able to follow the proceedings wherever they may be. The sole purpose, my lord, of this court to allow the coverage of the media was to afford the constitutional right of this society that has been referred to by the Honorable JP in this paragraph, who are for any other reasons that are unable to be in this court, and others for geographical reasons. I proceed, my lord, to say, moreover, in a country like ours, where democracy is still somehow young and the perception that continues to persist in the larger section of South African society, particularly those who are poor and who have found it difficult to access the justice system, that they should have a first-hand account, my lord, of the proceedings involving a local and international icon. The deceased in this matter, my lord, is also a person who has an attraction of the local and international community interest, my lord. It's my submission. Furthermore, my lord, the last few lines I quote from the same paragraph, I have taken judicial notice of the fact that part of the perception that I allude to is the fact that the justice system is still perceived as treating the rich and famous with kid gloves, whilst being harsh on the poor and vulnerable who have no means to come to this court, enabling a larger South African society to follow first-hand the criminal proceedings which involve a celebrity. So to speak, will go a long way into dispelling these negative and unfounded perceptions about the justice system, and will inform and educate society regarding the conduct of criminal proceedings. Close quote, my lord, in that paragraph. My lord, in respect of the fifth respondent, my lord, he has been photographed. He has been circulated on the media as one of the perpetrators, my lord. And now, it is time now when he has to listen together with his family to this witness. He has to listen to the evidence led before this court against him, together with his fans, together with the people who have interest in respect of respondent number 5. Now they are being denied that opportunity after they've had their son or their relative being circulated on the media as one of the suspects. My lord, further, I just go lastly to the order in paragraph 30 in which the state has referred this honorable court to. Paragraph 30, I think it's subsection 3, my lord, that paragraph of the order that was granted by Honorable J. Mlambo. For the sake of these proceedings, my lord, as much as court acceded to the application of Mr. Pistorius in that case, in that audio and visual recordings was disallowed during his testimony. But the order that was granted is as follows, my lord. I'm not sure whether the court is still with me.
Yeah,
Thank
I'm
you.
listening.
Paragraph 3, it's not paragraph 3, my lord, it's paragraph 30, sub 3, 30 sub 3. The multi-choice and pre-media are permitted to broadcast the audio recording of the entire trial in live transmissions, which is the position in this case, my lord. And I'm not making any submissions adverse to this, my lord. But now let's go to paragraph 4.5, which says, the evidence of all other witnesses for the state, unless such a witness does not consent to such proceedings, recordings, and broadcasting, and the presiding
You said
judge.
it's paragraph 30 point?
30.3, the first one that I read, my lord.
Yes.
And then paragraph 4.5.
Yes.
My lord, it says the evidence of all other witnesses for the state, unless such a witness does not consent to such recording and broadcasting, and the presiding judge rules that no such recording and broadcasting can take place. My lord, it is my submission, as I have submitted before, that when the court made this ruling, it was privy with the substantive application before it, which is not the case before this court. And leave was granted to Mr. Pistorius to say that the presiding judge, or unless the presiding judge rules that no such recording, in other words, leave and duty was shifted and referred to the presiding judge to rule, my lord, in case there is a witness who does not want to give consent. In this case, my lord, my submission is that on what basis can this honorable court be able to rule on the objections or on the application before this court? Lastly, my lord, the state submitted that the witness has put a condition, my lord, of which we're not sure whether it's coming from this witness, this condition, my lord, but with your respect, we'll accept it. It says the witness, if the audio recording is granted, she may not testify. I'm not sure that I'm putting it correct, but that's one of the grounds for the objection, my lord. My lord, I have a solution to this court and submit that this witness, who is the applicant, is a competent and compellable witness. Therefore, she cannot threaten this court. It is not by her choice. She is compelled and obliged to come and testify. If she refuses, the mechanisms are in place in our law to force him to come and testify under oath. Because these people, my lord, they need to hear their case without any unnecessary delays, my lord. So this court, my lord, should not be threatened by the fact that the witness might not come and testify if this court does not rule in favor of her application. Those are my submissions, my lord. I also have in my heads of argument included, my lord, that wherefore the fifth respondent asked that this application be dismissed, my lord. I just want to respond, my lord, on that to say, even if it's an obligation, I mean, my lord, even if it's an objection that is being raised before this court, but it's an application that is brought before this court to suspend the constitutional rights which are protected of the accused person. And therefore, my lord, with due respect, I submit that the application, be it an application or an objection, it must be dismissed, my lord, as the court pleases.
My lord, with your leave, to try and clarify some of the confusion which arose at the end of my address in response to your questions. I think the type of order which would put an end to any confusion would read as follows. Members of the electronic media be permitted to live broadcast the testimony of the witness by means of audio feed. Live broadcasts of the image of the witness will not be permitted.
Will you be infusing it into what your suggested draft?
Will I be including
I
it?
mean, I couldn't write as you were reading quickly. I'm saying, will you be effecting changes to your suggested draft?
Yes, I will.
Right.
If my lord wishes, I can prepare that in the form of a draft order for you to consider
All right.
during the lunch break.
Okay. I think it's lunchtime now. I suggest that we converge quickly outside for the way forward.
As a court, please, my lord, I just want to indicate, I just have one aspect that I want to respond to.
Oh, all right.
My lord, the issue of substance over form has been debated. When the last two witnesses, my lord, indicated and we made the request that that there should only be sound recording of their evidence, no one said, but where's the affidavit of the of these witnesses? It was an informal process, and that's how the these issues, my lord, are intended to be dealt with. I haven't heard a single one of my colleagues mentioning that this issue arises in the context of a case that's ongoing, a case that is partly heard. If one looks at, for instance, the Oscar Pistorius matter, wherein the JP said that the witness should consent to the broadcast of his or her evidence, what was intended was a simple, informal process. If one looks at the also the judgment of Van Breda, where the court says if a witness has got an objection, then the court should inquire as to the ground for such objection. Now, I had my learned friends making reference to motion proceedings accompanied by an affidavit. That is not intended for a matter that's ongoing, that's partly heard. A very simplified process is intended, that if a witness signals his or her objection to the live broadcast of his or her evidence, that there should be an inquiry. Now, witness number... Yes.
Does it not have to do with the fact, because I hear you comparing the two instances, the one in the Oscar Pistorius matter and what happened to Tumelo,
yes,
Madlala and Tukozisi Twala in this case. Number one, the defendants, the accused, did not seem to be strongly objecting to what was put in place. That's number one. Number two, on Monday, I can't remember exactly who among the defense counsels who said this applicant wants more. That was literally the terminology was the applicant wants more than what the other two witnesses required, and I understand them to be saying in that regard where she requires a shift even beyond what was considered and granted for purposes of Tumelo Madlala and Thokozisi Twala. It would have assisted if they had sufficient notice about it to be able to deal with it. I don't want to address the issue of whether there should be a motion court or not, but my major word in it is the notion of notice for them to be prepared for what is about to come.
Yes, well, the only distinction, my lord, is the fact that the witness is opposed to the audio recording of her evidence.
Yeah.
And we submit, my lord, that if on a proper understanding of the decision in Oscar Pistorius, that if a witness signals an intention that they are opposed to the broadcast of that their evidence, then my lord, a simple process should follow, and that's simply to inquire from the witness what the basis of the objection is, and as I say, that is also what is intended, the process that is intended in the Van Breda's case. If we were to follow the process that is suggested by my learned friend, my lord, this case will never be finalized. And there's this important distinction between the Pistorius case and the current one. The Pistorius case had not yet started. And that's why the court made the order it did, because the case had not yet started. In this case, my lord, the evidence has already been presented. And we submit, my lord, that that very important distinction should be made as far as this case is concerned, my lord. It is important, my lord, that the credibility of a witness should be preserved until a witness has testified. Hence, we are saying, my lord, that this process should be informal. I'm just trying to conceive of a situation where a witness must, under oath, set out the grounds on which she fears that harm might befall her or him, and the court then says, well, I don't believe you, and that witness must still testify under oath. We submit, my lord, that it is important that the credibility of a witness be preserved, and that the only way of doing it is presenting the matter as the state has done, as the court pleases, my lord.
I suggest that we converge outside. I will have to consider what has been presented, and I foresee that that task may not conclude today. So I suggest that we converge outside. We'll map up the way forward and come back and maybe roll the matter over overnight.
As the court, please, my lord.
The accused may rise. Subject to measures agreed upon amongst us around the problem we had around the transmission of electronic messages.
Manje ke kubeke naleyo nselelo sibenayo mayelana ke nokuthi kusakazwe kukhoma leli cala
inkantolo. We have all agreed that we shall seek to employ alternative means to prevent the problems we have from hindering progress in this matter.
Kanti ke sisonke ngoba sesathi uxoxisana savumelana ukuthi sizozama ke ukuthi kusetshenziswe ke enye inqubo mhlambe okungeyona engazosilethela kangako inselelo njengoba ke sesike sathola ke isithombe senselelo ekhona nje la enkantolo.
We aim to proceed further with this matter tomorrow at 10 o'clock or as soon thereafter as will be practically possible given the circumstances.
Inhloso ke ileyo yokuthi ke ikusasa sikwazi ukuqhubeka futhi ngaleli cala ngo-10 o'clock okanye ke ngaleso sikhathi ke ezobe sisivumela ukuthi siqhubeke futhi ngaleli cala.
For that reason this matter is postponed with the accused in custody. It's postponed overnight to the 18th of May 2023 for a ruling on the application by a witness that is to follow regarding the broadcasting of court proceedings.
Manje ke inkantolo ke iphocelekile ukuthi iqala nhleselwe emuva okufika kusasa ke nge-18 zika May 2023 kumayelana ke nokuthi inkantolo ikwazi ukuphana ngesinqumo esimayelana nesicelo esilethwe womnye wofakazi la enkantolo mayelana ke nokuthi icala lingaze lisakazwe bukhoma na.
Secondly and lastly, this matter is postponed for further hearing.
Kanti ke okunye leli cala lihleselwe emuva nje ukuthi liphinde liqhubeke ngamanye amazwi lokuliqhubeka liqulwa. Yazwakala?
Permission, I'm unfortunately not available tomorrow, so to be excused for tomorrow, I will get someone to come and note the judgment on my behalf. And my lord, the order I mentioned, I will include it in the last paragraph of the heads of argument I send you later today.
Where is it, folks?